time this issue was before it to abandon the road, it was just the word close was used instead of abandon. So we are before you today to wrap this thing up and put this issue to bed once and for all and use the word, we request that you use the word abandon in your motion and put this to rest. So, thank you.
Yes, Steve?
Mike, I was party to that negotiation, and that was the intent of that contract with Don Schofield, was to abandon that old road.
Okay, thank you.
Mary, do you have any, you're a public works director, you're gonna be accepting a new road.
And I do have some concerns about it, and would like to chat with Corey about it at some point.
So what are your concerns as far as that road?
Well, my concerns are basically maintenance costs. It's a single lane road, how far up, is the county's obligation to maintain that road? With the traffic that's proposed to be on that road, it's gonna have to be widened. Who bears that financial responsibility there? Looking at the recent work that we did on determining the cost to build county road to county road standards in the southern end of the county, it was gonna be about $680,000 just to build a gravel road. So if we're looking at, over $400,000 a mile to build that road up to county road standards. And that's a concern because I do not have the money set aside for that.
So are we obligated to bring it to a county road standard? I don't know, I don't think we are.
If we have to widen the road for access, because, right now, the issue is people coming in and coming out with travel trailers. The easement is that a 40-foot easement or a 60-foot easement?
40.
Through that?
That's 40.
Okay, so we're limited there, in some regards, and what is the road department's obligation to that? So that's something that I would like determined before a final decision is made, so that we can be sure that we have, the funds to do what we need to do up there.
Yes, Steve?
Might I suggest that you fulfill the original contract obligation to Don Schofield and his estate and the new owners by abandoning the initial road. You have access, you have some in-house bookkeeping that has nothing to do with not fulfilling the Schofield contract. So if you could abandon that, it would certainly clear it up for the new owners.
Is there any other public comment? Okay, we will.
I would just say you could do what Mr. McCullough suggested without violating the statute. The statute specifically says the board may not abandon a county road or right-of-way used to provide existing legal access to public lands or waters, including recreational use, unless another public road right-of-way provides us substantially the same access. It doesn't require a county road. This has already been granted and accepted by the county as a public road right-of-way, so it would fulfill that limitation.
If there's no further public comment, we'll close the hearing and go to the decision to abandon Copper City Road.
Mike, I have a few questions if I may.
Okay.
Was there a legal ad done for this meeting?
No, we were told that there's no requirements on resolutions for, there's no requirement time frame wise. It was put on the agenda as a public hearing. Of course, there was no requirements for a time frame when you had to, how many days you had to do it or anything for the public ad.
So, was the resolution published for the public upstairs in the clerk and recorder's office?
No, not that I know of.
I don't disagree with anything that was said, but with all the challenges against us and process, I'm not sure that we have complied with MCA. Statute, and I don't know what it is off the top of my head, I would leave that to, those who are smarter than I. But there is statute that says any resolutions require 2 weeks' notice in the paper. We do a legal ad for those, I believe that's also in statute. I believe that we are not complying with the law by not following that MCA. So I would suggest we just put this on 2 weeks, legal ad, publish the resolution so that the citizens are aware.
Well, I guess we asked that question, so Corey, help us out there.
Yeah, I'm looking for the exact statute here. 7/14/2615 says, an order to abandon a county road is not valid unless preceded by notice and public hearing. We met that. It's listed on the agenda
But a
as-
public hearing,
It's listed County Attorney, Copper City Road, County Road Abandonment and Establishment, Public Hearing and Decision. We just had that. But also, I guess I'd also point out, I don't know if it matters to you, but 7/14/2609 says the proceedings provided for in this part shall in no way be affected or invalidated by the failure of the board to give any notice or do any act provided for in this part.
read that again?
The proceedings provided for in, oh no, never mind, that's referring to just damages. There's no damages sought, so it doesn't matter.
Can you read the public hearing statute? It's 7-1 something something.
4131.
It should be 4131.
So, 7/14/2615. Abandonment or vacation of county roads. All county roads once established must continue to be county roads until abandoned or vacated by, and it gives 3 different ways you can do that. In order to abandon a county road is not valid unless preceded by notice and public hearing.
And by having it on the agenda, we have notice of a public hearing, right?
No, and that's why I asked Corey to read the statute on public hearings. Public hearings are required to be noticed in the newspaper of record. Bobby, probably more of an expert than I am, but 2 weeks' notice with a legal ad. I don't believe that was done, and it's 7-1 something, I don't know what it is. Bobby said 2121, is that
It was
correct?
4131, but that was in 2017. I'm looking at the 2018. It is 2 weeks. For a public hearing, you have to have a 2 weeks notice. I'm trying to find the 2018 one here.
A public meeting and a public hearing are 2 different things, and they're governed by 2 different areas of statute.
Yes, Win?
Mike, just out of curiosity, I mean, if this started in 1998, Steve McCullough was the commissioner, and hasn't this already gone through the process of being closed? This is no longer a public road, this is no longer a county road. This road doesn't even exist, this was done back in 1998. So I guess this is in regards to what the attorney for the landowner said, this is a cleanup because the word closed was used versus abandoned. But this process should already been done. You're trying to abandon a closed road. That was closed and abandoned in 1998. So it seems like we're reinventing the wheel for something that's already been done 2 decades ago. Unless I'm completely off my chart, but this road doesn't exist. This is just a clerical thing and clear up some paperwork. So I'm not really sure why, in the sake of your time, unless you guys have lots of time to spare, why do you wanna go back through the whole process that's already been done in 1998? So that's just a question I have.
I guess the answer would be because the wrong word was used. I don't know what else to say.
Well, yeah, I mean, and I understand that as well, the context. You know, unfortunately, we're trying to rewrite our own history because we wanna be politically correct on everything in the world now, but was the context used in 1998 by the people that were sitting on that board, was it to close and make it go away? They obviously did, because they reseeded it and closed it off, and it's no longer in existence. So, I mean, I guess that's where, I mean, I hate for government officials to spend all their time reinventing the wheel to make things up to a standard of 2019 in regards to verbiage and language, when it worked 2 decades ago. So, this is my opinion.
I guess I'm not seeing the double publication requirement. I'm looking at 7.1.41.31, public hearing. When required, the governing body shall conduct public hearings for the purpose of providing reasonable opportunity for citizen participation prior to final decisions. And it goes on about the requirements. Public hearing provide for submission of oral and written testimony for and against the matter. Public hearings may be held at regular or special meetings of the governing body. Hearings may be adjourned from day to day or to a date certain. Except for budget hearings, the governing body may designate a subcommittee or a hearing examiner to conduct a public hearing. There are requirements for double publications in other areas and for other actions, but it's not public hearing. That's if by law, a matter must have a legal notice. But I haven't found a statute that applies specifically to public hearing. I looked at that back, whatever it was last week or when that was asked. So I'm not seeing that is a requirement for a double publication. There are some matters that are, but you have to look at that specific item. I'm not seeing it for roads.
Mr. Chairman, I'm gonna go get our county policies and Title VII. Bobby, what was that statute again that you just confirmed needed the 2 weeks?
It's 4131 and then 2121 also. On 2121, I'm seeing just once a week, at least once a week. It doesn't tell me a requirement of how many weeks.
And was
No,
that
that's-
7-1 on both of those?
Yes.
Okay.
So Corey, did you look at the petition that Ralph Schofield brought?
Yeah.
Did it specifically state abandonment?
Yeah. And also in the agenda, in the notice in the agenda, it specifically included abandonment, and it asked for any, I'll look at the exact language.
Reclaiming?
Yeah, any quick claim deed that may be necessary as a result of it, which is indication of abandonment.
I didn't get our resolution that we do at the beginning of the year. That might also have this. Might be in Title II. So our meeting policy, which is a legal requirement that we have, states that public hearings will be advertised per section 712121 MCA in the local newspaper of record. So 712121 states first of all, subsection 10 is new, I believe as of this legislature, or the last one. If a newspaper fails to publish the second notice, the local government unit must be considered to have met the requirements of this section, as long as the local government unit submitted that required information prior to the submission deadline, and the notice was posted in the 3 public places. So that states that you need 2, and then it's in here more clear, I just can't find it yet. Bobby, do you know what subsection that
I
was?
am still looking.
All right.
They've changed it so much.
It says here, the newspaper must be published at least once a week. That's not the notice. It's subsection 6, under 712121. The notice must be published twice, with at least 6 days separating each publication.
That doesn't apply to all things published. That wouldn't make
No.
any sense because we publish our agenda once a week prior to the commission action.
Correct.
It's when something
But we're talking ab-
specifically
But
has
we're
to.
talking about a public hearing. That's what this has to be to abandon a road.
But-
And I think you guys just read that, notice and a public hearing. So public meeting is one thing, public hearing is another. This is a public hearing for this action, and we have not complied with state law.
Well, the preamble, we have to look at subsection 1 of this statute, specifically says, when a local government is required to give notice by publication. There's a lot of items where you have to give specific notice by publication. Sheriff's sale, for example.
I'm only talking about public hearings. This is a public hearing. This, I think we just need to make sure we do it right for a variety of reasons. It is in our notice of meetings. So,
Well, I sent this to you on August 1st, and then I've had at least one other follow-up message with documents and requesting to be placed on the agenda, and never heard back. I think this would have been helpful had you had a concern about this, that we, sometime between August 1st and today, say, let's do 2 weeks publication on it. That would have been helpful.
and I think you're right. I didn't realize that we didn't have the resolution, that it wasn't published, that there wasn't a legal ad. So all I'm saying is, I don't have a problem with the action as long as we follow the law to get to it. And I just don't think we are.
Steve, did you have something?
I think the action was agreed to in the original contract with Don Schofield. I think you're just completing a contract by abandoning that road today.
And how do, I'm just looking through the commissioner minutes from those dates, and you've already had a couple public hearings on this already,
We've had 3.
right?
Mr. Chairman, I have a question,
Yes.
and I guess this is for Corey. Corey, in '98 or whatever year you said this was done, if they had used the word abandon, we would not be here today, correct?
That's correct. or 2012 or
Or, right.
2015.
So it is literally about misuse of a different word.
So, Corey, let me ask you this, if we go ahead and abandon this and then we end up in a lawsuit, where are we at with that since we didn't publish a notice for a public hearing for 2 weeks?
Well, I don't believe that interpretation is accurate. I believe we've done the notice that's needed. If you wanna wait and do it in another week, ask Mr. Goss if he has a problem with that. Doesn't matter to me. It's based on the research that I've done. This issue's almost 20 years overdue. I think you've given more than enough notice, but if you wanna wait a week out of caution, go ahead and,
So then would we have to go through this entire process again for another public hearing?
well, the statute I read on public hearings says a public hearing may be continued from day to day or week to week. If you wanna put it on the table and take it back up next week, I think you're fine. Provide opportunity for public comment next week, and you're good to go.
I'm just wondering if we already had this public hearing and we never advertised, are we having an illegal public hearing, then we're gonna, recess an illegal public hearing and then open up another public hearing that's actually an illegal public hearing to begin with? Where are we at?
Well, as has been stated, I know we've had 3 public hearings on this. We had one in 1999, we had one in 2012, we had one in 2015. So this will be our 4th public hearing. Sooner or later, it's gonna take.
That is a good example of the frustration that people have with government. I mean, there's the intent of the commission to abandon this road. Let's get it done. I'm gonna make a motion that the county officially abandon the old Copper City Road and establish the new Copper City Road as a county road.
I'm not going to participate. I do believe that we are violating 712121, or 1212, no, 2121. And 7142615.
I'll second it only for discussion. I would have to say that we're sitting here discussing the government possibility. Well, here's another one I'll throw you. So we go ahead and pass this thing. So then somebody gets a hold of it and somebody comes back and sues. So now we've got Mr. Goss held up again for another 5 years until something gets into court. Because we don't know if we're on the right side of whether or not we had a public hearing advertised for 2 weeks or not, or whether a public hearing that's already been held 4 times is allowed to continue to carry on if it's already been adjourned twice, or if this is a public hearing that wasn't properly advertised, but then we continue the illegal public hearing to have another hearing to open the road or close the road. So eventually, Mr. Goss ends up down the road in court 3 more times because we had a public hearing that was illegal after 3 other hearings that were legal. And I think it would be wise, as much as I don't want to continue it and advertise a public hearing for 2 weeks and then everybody's out in the clear. I don't necessarily agree with it, but then again, I'm not a lawyer and I don't wanna get tied up with any anymore.
Your legal counsel says it's okay to pass it.
County attorney is the counsel to the commission, is that correct?
That's correct.
Actually, by statute, he's our advisor.
I guess, Gene, what would you say? It's your property.
Well, I think what Mr. Folkford said, I mean, this is the poster child for being frustrated with government. And I've already spent a lot of money and time, we bought the property from the Schofields. We're told and presented documents that it was abandoned, both in '98 and 2012. And both of those were public hearings, and then I went through a public hearing and the whole process in 2015 because it still seemed like there was a gray area. So there's been 3 public hearings. It's semantics on the terminology. There's no road there. It's not possible you can use the road. You got a county road that's works for the BLM and the state. And we run our cows out there, and everybody seems to be happy. So this is just it's a housekeeping item that, you know, I think it seems fairly straightforward. You've got a past commissioner saying he was there, and that was the intent of the commissioners. And we've got the documentation that says abandoned. I mean, I'm kinda out of patience with it, and so, you know, I pay my taxes, I obey the laws, I'm a good citizen, but, you know, I'm at a point now where if we can't get some kind of resolution, which anybody with common sense, doesn't need to be a lawyer, ought to be able to agree with those documents. And
Mike, and I have no dog in the fight, no skin in the game, we all know that. In regards to the frustration that Mr. Goss is feeling, I can definitely empathize with that, and the fact is that at what part, you know, we're sitting there going, are we having a legal meeting, are we doing this, we're doing that. Let's be honest, let's go back to the basics. He owns the land both these roads sit on. The one thing that you should fear from a lawsuit would be the fact is not taking action. Because that's, in a sense, that's what I'm hearing, is that he's gone through this over and over and over again. And the county, the government has failed to do their job accurately 3 times prior, okay? So, I understand where you're at, I understand where you're at, I understand where Commissioner Ober's at, but I also understand where this gentleman's at. And we're getting too far into the weeds. He owns the land that both these roads sit on. The only person that's gonna sue you is him. And I think failure to take action is you're opening the door for that to even happen quicker. And that's just my opinion, and I know, only thing I know is I've been sued 6 times in the last couple of years, so I have an idea what it's like to get sued. So, I would probably listen to the fact that Corey is, as the county legal advisor, whatever you wanna call him, plus the fact Mr. Goss's attorney saying this is house cleaning. 3 public hearings in 2 decades, I think this dog has been beat enough, it needs to be either let out in the kennel or put down, but I think something needs to happen. And that's just, like I said, I have no skin in the game, no dog in the fight, but I think what Commissioner Folkford said, this is government overreach in its finest, so that's all I have.
Mike, as a lifeline, here's just a suggestion. Why don't we just postpone by 1 week? We've got the public comment. Mr. Goss doesn't have to come back, unless you want to. But we've got the public comment, it's all on record. Let's go ahead and confirm with Tara Depew and Susan Swinley. They are land use attorneys with Mako. If I am wrong, I will buy everybody here donuts next week. If I'm correct, then let's do this right to keep the county out of trouble. And
I
that's
do-
not bribery, I'm just being funny. I won't buy anybody donuts. Thanks, Shirley.
Just a comment. I think it's a moot point. I think this whole thing needs to be over. You were a commissioner in 15. The public meetings have been held. It's a moot point. It's housekeeping. It's one word. Pass it and give Mr. Goss peace of mind.
And that's the problem I have is it's one word.
It is.
One word is you did not use abandonment when you had the other 3 public hearings, but the other one word is advertise. You did not advertise a public hearing for 2 weeks. So which one of the one words, or when we end up in the court, what the hell one word matters? That's the whole problem with the damn thing, is one word was not used when it was supposed to use 3 different times.
Correct.
So now we're sitting here supposed to use the right word, but we're not advertising it in the right way according to our resolution to have meetings.
Well, that's a mixed opinion also, it sounds.
Yeah, I know, everything's an opinion until you get somewhere and somebody has to pay a bill.
That's right.
Your legal counsel says you're on solid ground.
Yeah.
So I guess we'll call for a vote on the resolution. The motion's been made to approve the resolution to abandon the old Copper City Road and adopt the new Copper City Road as a county road. Is that what we're still doing, or are we only abandoning and waiting on the adoption?
It's up to you. You can bifurcate them if you want to.
My motion was for both.
Your motion is for both?
Yep.
I guess we'll call for a vote. All in favor? Aye. Pose same?
I'm not opposed, but I'm not going to participate based on what my previous statement.
Motion carries. Thank you.
Thank you.
Melissa, did you get a copy of this? And we go on to 11:15, adopt a collective bargaining agreement for the sheriff's office.
On this one, I'm going to just jump right in and move that we get her done. Move that we sign the collective bargaining agreement plus any with continuing health insurance contracts that go with it.
Is there a second?
I guess I'll second for discussion. So, Wynn, you got the final one?
I do, I think, well, I think I do. Did you guys get it? It was sent out, I printed it out this morning, so I only have one copy. Some of the things we went through, just so we're clear, in this last one, when you guys had a meeting last Monday, in regards to that, one of the, I think there was some miscommunication of what, I was presented some language, and some draft stuff. I wasn't presented the final document on what you guys were looking at. So that's what I asked. I was at a meeting at Mako that week, or that day, so Corey, I obviously told Corey I wanted to be able to review the document. Part of the things was some of the language which sounds silly to most people, but a lot of the language in there said Sheriff's Department, and we all know how I feel about that particular language, since it is the office of the sheriff. So I had them change that, and then on the back, the other big one was just an Exhibit B. Under the uniform stuff, there are some things that have changed, in part as to the dispatch control detention, is that there wasn't anything, there was a dress shirt, but there wasn't, there wasn't a dress pants or the metal badge. As part of what's transpired in the last couple of years with court cases and everything else, our detention, our dispatchers have been called to testify on what's taking place within the jail environment or what's taken within a call. And so now our dispatch and detention both have a dress uniform with a metal badge. So that was changed in there to make sure that correlated correctly with what had transpired. And the other thing, there's some other verbiage, I believe, on paragraph, I know it was paragraph 9. I think it was page, I think it was page 3, paragraph 9, article 4. One of the things I also want to make sure we do is we want to make sure that anything we do in regards to the union agreement or collective bargaining agreement also fall within the Montana Code annotated. So that information was put in there as well. I want to make sure in the future, whoever sits in this seat or whatever, that we follow the laws as they are written and not try to circumvent them in any fashion. So those are the changes that I requested. It's been back through, I think you guys have looked at it, I've looked at it, I don't have any heartburn over it, the union doesn't seem to have any heartburn over it. So I think we're good to go. We can get it signed and move on to bigger and better things. Okay. Any questions for me? All right, so I think we've conquered a hurdle, so. Thank you guys, I appreciate the time for letting me review it. And, well, I got this one, if you guys wanna sign this one. Now, there was some format issues, this is the only one I have, so I didn't think about printing them out.
I think Debbie had some,
She didn't print them out either.
okay, did you get all your questions answered, Debbie, on that?
Well, that's housekeeping.
Yeah.
Okay,
Yeah,
okay,
that's
so-
housekeeping later.
So one of the things, some of the format issues, obviously you see on the Exhibit B, I think that's some of the format.
Yeah.
My conversation with Debbie and with Aaron has been, let's just get it signed, we can fix the grammatical stuff in a hard copy and format wise. But for all intents and purposes, I think that getting to that is where we need to be, so. So I will give you guys this one to sign and make that the original as everybody sees fit.
okay.
And then we'll go from there, so.
Any other public comment? Call for a vote, all in favor of signing the Teamsters local union contract, all in favor?
Aye.
Opposed, same, motion carries.
In regards to the conversation that we had earlier last week, I did also, so we have some issues we're gonna try to resolve. I will just take a few minutes of your time. In regards to that, one of the issues we're facing right now in our dispatch center is we keep losing some dispatchers on a very rapid rate. As I talked with Commissioner Folford on last Friday, I was just advised Thursday afternoon that I have not only one leaving in this month, I also have 2 that are possibly gonna look at accepting some positions as well. Unfortunately, what that does is that also puts us in a part where we cannot operate that dispatch center. That's a huge problem. That dispatch center closes, that means I had to close a jail, which means I gotta move those 46 inmates somewhere else, and we lose a whole bunch of patrol guys quick, fast, in a hurry. My analogy to this was similar to the World Trade Center. You put a plane in the right spot, the whole building comes down. And I can't keep that dispatch center open, the whole thing comes down. And so I have asked Commissioner Folford to sit down with the other sheriff, myself, and try to come up with some sort of plan or idea on how we can recruit and retain some dispatchers. I did talk with Aaron, and I said, is there any possibility that there's going to be some rollback from the union on this? And she says, no, we support that. I will have a discussion with my staff as well, because I understand the Me Too part of the clause within the contract, but the reality is if that dispatch center closes, no one's going to have a job, so it really doesn't matter in a lot of aspects. So we have to do something to salvage that particular division of that office. And I'm not sure what it's going to take, but the undersheriff and myself were very concerned about what is it we can do to make sure these people stay with us. We've got a lot of time, money, and effort invested in these folks, and for them to want to leave in such a rapid rate is very concerning. So we've made some changes over there already, but it might not be enough, but we're going to try to sit down and have a planning session to try to figure out what might work and what can't work. So, yeah, in grand scheme of things, this union contract, if things continue down the path we're on, is going to be completely irrelevant, in the most part because we're going to be meeting the undersheriff and maybe a deputy or two, if things continue down this path. So we really got to work on retention, and I'm not sure what that's going to look like yet, but it's a serious enough situation that needs to be addressed fairly quickly. So, okay.
All right.
Any questions on that?
How long does it usually take you to train when a new
8 to 10 weeks. And so we did hire 2. One's in training right now. Unfortunately, it sounds like she's not very happy because somewhere between interview, accepting the job, and getting into training, she didn't realize that she's going to have to work nights. Yeah, that's part of the gig. She was not very happy about that. And the other one hasn't actually even checked on to that. So it's a process. And then the other downfall of that is it's also 7 weeks at the academy, 4 weeks for detention. I have 6 right now, 2 for dispatch, and they're trying to go to 3 on that dispatch class as well. So you're looking at about 17 weeks total to get somebody up to speed on doing that job. And so it's quite a daunting task. So I just can't throw somebody in there because there's 26 cameras, there's 46 inmates that got to worry about, detention staff, patrol staff, and they have to run 2 different phone systems and 4 computers at one time. So you have to be fairly multitasking to get that mission accomplished. So, any other questions? Okay, so thank you.
Okay. Sheriff's
Perfect.
I didn't want to preemptively sign that with everybody else.
Okay, move on to our 11:30 Debbie Kelly tax evaluation report. Okay,
We all got our emails last week. We got our valuations about 4 o'clock last Monday. And essentially, in a nutshell, there's a copy in the book upstairs, if anybody wants to go look at the special districts, what Department of Revenue assessed, it's in the budget book upstairs in the clerk and recorder's office up there on their countertop, anybody go look at them. We roughly are seeing a 6% growth, 5.47 of that will be taxed. However, and that's roughly a difference in $104,400 from last year's value to this year's value that they can tax. However, as a result of the higher revenues, the meal number decreased from 108.55 to 104.73. So it'll be a decrease of 3.52. In layman's terms, that's the number of, the percentage is how much those 106 meals, 104 meals will be divvied up amongst those that get the floating meals. So everybody will be reduced about 3.52%. Caveat to that is the value is more, so while the meals went down, there's gonna be more revenue because the growth we sustained increased the money we'll get for those. Right now it's come down to working numbers to make budgets match the expenditures, revenues, where we're sitting, make some of those final decisions moving forward.
So what was the value of the mill?
It is 16,629. 17,629.
Yeah, something.
Last year was 16.047. Thank you.
Debbie, can you share with the folks here about 1510-420, why we lose the mills when we have that kind of growth? Do you know what I'm asking? The folks who have already been here do not realize a 6% growth in their taxes. They're protected from that by that statute to just 0.5% of the last 3 years inflationary increase.
The state limits, that statute limits the amount that we can tax or see in tax revenue. The rest of that goes to the state and the funds other things. We get it back in other ways through entitlement, local vehicle taxes. So it reduces the mills for us to generate revenue. And we don't get to see that. So you would see a huger increase on your taxes. So it kind of keeps things at a more normal level. Not really. So we don't see a big, huge jump in our taxes. Hard to explain.
Thanks.
Did you say, Deb, that the overall increase was 104,000? Is that what you said?
104, 440. That's what's gonna be, that's the tax revenue we'll see. The value is the difference between that 16,047
Okay.
that's actually taxed. So that you can't tax all the growth. It reduces the amount you levy. Last year we only were able to see like 3% levied. This year it's almost 5.5. So that's where that growth and that 104,400 comes from.
Okay.
Is that. So the mill is like think of it as a placeholder. You gotta come up with a money value somewhere, so it's kind of the number that helps you get to the monetary value that we can charge on taxes. And we're kind of in a lag as well, so all the growth that we thought we'd get last year is actually what we're seeing this year. So all the extra growth we're seeing out there now, we'll recognize next year, because there's a lag time in how they set up their valuations and use the formulas to determine what we can charge.
Are most of our budgets prepared pretty much in line with this?
Yes.
Okay.
There's a few that are waiting on end of the quarter revenues that we're still kind of on the fence with. But with having everybody submit balanced budgets based on what they expected for revenue and their expenditures, we're doing good,
Okay.
better than last year.
So one thing we're gonna have to do is make sure that next week the agenda allows us to do some serious budget work. Because we always say after the valuations come in, which was the 5th, we have 30 days, which is September 3rd. We don't. Debbie has to have the budget done 2 weeks after getting those values so that she can have it published. We can have the public hearing in the newspaper for 2 weeks. And that the whole budget sits in the clerk and recorder's office so that anybody can come in and look at it, take copies, what have you. So we have to have that done next week so that she can get that done, so that we can have all that done by the 3rd. So that'll be a busy week on budget.
Okay.
And there was some argument last year that we could postpone adopting the budget. That 30 days after getting the valuations, as Debbie and Michelle shared last year, is solid. There is no ability to push that off. And we did get Mako to confirm that as well, although you guys were quite clear, so.
Well, and Department of Admin is now, and Department of Revenue has kind of taken over this process. And Department of Revenue's got some more stricter guidelines that we have to have certain documentation and turned in. Otherwise, we could be fined, which will slow things down for grants from the state. That's just a road we don't want to go down. So it does put a lot of pressure on us now with these tighter reins to get things done. It does put a lot of work.
Yeah, I remember them saying that they could withhold grant money.
Mhm.
Sure.
And it goes clear through until we got budget done and they accept our budgets and then, yeah, so it's,
Okay.
yeah, it's not just us, they're tightening down on all the counties, but we don't wanna lose our grant funding because we rely on that a lot for things. So it puts more pressure on us to make sure we get it done first time.
Anything else? Thanks, Debbie.
Thank you, David.
Thanks, Debbie.
We will have to work. Thank you.
11:45, county attorney authorization for outside counsel due to conflict of interest.
So I'm just trying to provide an opportunity for another attorney to look at some issues that I am conflicted from addressing. I understand that I provided a draft, do you have that, Commissioner Fulford? And then I understand Commissioner Fulford has a different draft that he's considering, so I can answer questions on what's the best way to go forward with it. Basically, short version is one option is under 714-2705 allows the county commissioners to employ special counsel to assist in any criminal matter that's basically at my request, that's pending in the county. And those are ordinarily, I've done a couple of those lately, one where
Is it two?
an attorney is assisting, I've got multiple copies here if you want it.
I'd like one.
Yeah,
I have just one. Is there two
I
resolutions?
think on this one, there's only
Oh, all right.
one page.
So,
That's this one? Yeah.
I've done a few of these lately, where we have an attorney who, for example, one at Department of Justice, we talked about probably a month ago, young lawyer who's getting into a certain specialty of cases, and I have one of those cases, so I invited her to come down and try the case with me, basically to assist her. Way back in, when I first started as county attorney, I had a couple where we had DOJ lawyers come on when it was a unique or a complex case. So this is one where I just feel like I have a conflict and need to let somebody else drive on that one. That's one authorization option. The second one is the one that Commissioner Fulford has, and that's under 7/4/2707, and that allows basically two counties to agree, two commissions as well as two attorneys to agree to basically do a contract for services. So that, I'm familiar with this, most recently, Fergus County does some contract for services with Judith Basin County, where they have a part-time county attorney in Judith Basin County, but there's certain types of cases she just doesn't do, really. And so they've contracted between the two counties, and Fergus County does those on an ongoing basis. That's kind of an interlocal agreement option. That was the option that was suggested to us recently. I think the first one is the more appropriate fitting action, but either one is potentially appropriate.
Is this the one that you're recommending, Corey?
Is that the 2-page there? That's the third stanza is in under 7.4.2705? Yeah, that's correct. I grabbed my book.
Yeah.
And here's both those statutes. You wanna read them, 05 and 07.
What's interesting about this, if you look at these sections, I mean, clearly you're seeing a delineation between small counties and large counties. That one's limited to counties that have a taxable valuation of $50 million or less. There's another section that I think I've talked about with a couple of you where I could appoint, by statute, I can have a deputy and a chief deputy, but only if I'm a county, if we're in a county over 30 million valuation, which we're not. So that's another example where I could appoint a deputy county attorney, but that would only be done with your approval. So there clearly is in the county attorney world, there's kind of a recognition that most of these situations where you have someone from the outside are with small counties, which is our case.
So is my understanding, Corey, that this person would just look at whatever these issues are and then decide whether we're gonna go forward or not, right? I mean, that could be the end of it right there, right?
Yeah, that could be the end of it. So they have that authority to decline a case, prosecute a case, to make a deal, to resolve a case. Everything that I currently do with my criminal cases, they can do. Without my approval.
So what role would the county commissioners have in this special counsel as far as for guidance or whatever?
So under the one that I provided, this